Topic. Hello, everyone. My name is Ifama Odunlami, immigration attorney from the Odunlami Law Firm, and I want to talk about a special topic today. And this is a topic that I decided to discuss because of the consultations I've had in the past couple of weeks. And so I'm going to wait for people to join us so that we have more people in here. So, the topic of today, like I said, is based on certain consultations I've had. And so I feel called upon to basically do this video because it's really important that people don't miss out on getting a green card for their children, or the children themselves don't miss out on getting a green card. So, what am I talking about? I'm talking about special immigrant juvenile status. So, I'm on Instagram, YouTube, Facebook, and so let's get started. So in the past couple of weeks, I had a couple of people who came to me trying to figure out whether they could qualify for a green card, and I asked them a couple of questions, and they would have qualified if they were under the age of 21. They would have qualified for special immigrant juvenile status. Now, I had another consultation where this young person had filed a petition with his mother. His mother actually had filed a petition for him, and the I-130 was approved, but the I-485 was denied, and he didn't know why. So he and his mother had a notario, or one of this people who hold themselves out to be an attorney, but they're not really an attorney. And sometimes the clients don't even know they're not attorneys. So they assume that they were working with an attorney or a paralegal or a notario. And the person filed a petition for them, for the mom with the green card holder filed for her child. So the reason it was denied was because at the time the mother filed for the child was out of status. So that child cannot adjust their status within the United States, right? They would have to do consular processing, and there's all these issues with leaving the country if they don't qualify for a waiver or a pardon, right? Now, I asked him a couple more questions, and if when his mother filed a petition for him, they had consulted a lawyer, they would have known that they qualified for special immigrant juvenile status, and they could have gotten their green card without having to leave the country. And so that's why when you do a consultation with an attorney, you're not just consulting for the things you think you qualify for. The attorney is also screening you to see the other things that you may qualify for that may move faster for you, may be more convenient for you, may be better for you. So what I have to say today is if you have a child who is under the age of 18 or under the age of 21, do yourself a solid and talk to an attorney to see if they qualify for special immigrant juvenile status. So I'm going to talk about that today, and I'm going to talk about the things that the elements that you need to be able to win this type of case. Now, special immigrant juvenile status, getting a green card through a special immigrant juvenile status is different from other ways that you get a green card because there's a portion of it that happens in family court, right? And I think it's because of the special nature of this type of immigrant visa. That's why it's called special immigrant juvenile status. It's special, it's different. So let's start from what would qualify you. Then we'll go into the procedural, how to go through the application process. So number one, you have to be single, which means you're not married. Now, if you have been married in the past, but at the time you're applying, you are no longer married or your spouse has died, you may still qualify. You should still qualify if you meet all the other elements. So the second element is that you have to be under a certain age, and this depends from state to state. In states like New York, New Jersey, and I believe Maryland, right, the cutoff age is 21. In other states, it's 18. So that depends on the state. So this portion of the analysis is what you're in family court. So like I said, it depends on what court you're in. In some states, it's 18. In some states, it's 21. But I'm going to caution you and I'm going to urge you not to wait until a month before you turn 18 or a month before you turn 21. And the reason is because the process that takes place in family court requires family court to give you a hearing date, and your attorney is not going to have any control over that. Some courts are really backlogged, so you may not be able to, after you file the application, you may not get a court date at the time you want to get a court date. So you want to really begin this application process at least 6 months before you turn 18 or 6 months before you turn 21, depending on which what cutoff your state requires, right? So now we've talked about being single, which is being unmarried, and we also talked about being under the age of 18 or under the age of 21. The next thing that you have to prove is that reunification with either one parent or the other parent is not possible due to abuse, abandonment, neglect, or some other category, right? So it doesn't have to be reunification with both parents. That's not possible. Just one parent is enough. We only need to show that one parent has abused, abandoned, or neglected. And the definition of abuse or abandonment or neglect depends, again, is state specific because this is family court. In some states, such as New Jersey, even the death of a parent is abandonment. Did you hear that? The death of one parent is abandonment. So if you have a parent who's dead, that qualifies you in New Jersey to make a case for abandonment. And the reasoning behind that is that that parent is no longer available to give support or provide for that child. So that's abandonment, right? So you want to realize that, this nuances, in different courts, make a difference. And so you really want to talk to an attorney to figure out what you have to prove in the state that you're in. So now, what are we talking about when we say abuse? Now, abuse it could be physical, it could be emotional, it could be psychological, it could be verbal, right? These are fact-specific scenarios where your lawyer would have to, show by testimony, by affidavits, and by testimony, because you will appear in court for hearing, that there's been abuse. Like I said, it could be physical or it could be, non-physical. It doesn't have to be physical abuse. I've said this many times. Abuse, there are many ways that a person can be abused, right? Now, abandonment, pretty much what it sounds like. A parent who has just left the child to their devices, is not doing anything for them, is not keeping, communicating with them, basically has abandoned them. Now, neglect is usually the failure to do something. As a parent, you have the duty to provide for your child, provide food, shelter, education, and all that, right? So if you have a parent who's not providing for their child, that parent could arguably be guilty of neglect, okay? So those are the three things you need to prove: abandonment, neglect, or abuse. And there's a category that says, or some other category, and that basically could be something else that doesn't quite fit neatly into these three categories. And that, of course, is dependent on family law. So now, another thing that you would need to prove is that it is not in the child's best interest to be returned to their country. And to prove that, you want to look at country conditions, what's going on in that country, and what would be the child's, how would the child's life be in that country, as opposed to where, as opposed to the United States, where the child currently is, right? And to do this, typically we are able to prove, like I said, show country conditions of the country where that child is, right? And then the fifth thing you need to show is that the child has been declared dependent on a juvenile court. So that really means that the family court has jurisdiction over that child, which means that, like I said, the child is either under the age of 18 or under the age of 21, and depending on the state, and somebody is there supporting the child. The child cannot support themselves, is not in a position to take care of themselves completely at this time. So this the 5 things we discussed is what your attorney will prove in family court, right? And upon conclusion of that proof, usually by submitting a brief and by taking testimony in court, the judge will render a predicate order, right? That order has to spell out with specificity the reason that the judge is making the findings, because USCIS really wants to make sure that the judges are following their own rules. So they need to be able to express the reason why this findings have been made. Now, once you get a predicate order, then you file that. Then the immigration portion comes up, right? You file the form I-360, right? Now, the form I-360 is a form that's being used in different ways. We use it in VAWA. It's also used with widowers petition. It's also used with the religious immigrant visas. So you want to be careful that you're completing the section that pertains to special immigrant juvenile status, right? And then once you file that petition, now there are different ways to file that petition. You can file the I-360 alone if there is no, if your priority date is not reached. But if there's an immigrant visa available, and that's based on the country you're from, then you can do it in one step. You file the I-360 and file the adjustment of status at the same time. But if you do not have an immigrant visa available because you're from a certain country, then you're going to file the I-360 first. When that's approved, then you file the I-485, and then the I-485 is what gives you your green card. Now, some young people are in immigration proceedings, right? They're being deported. The good news is, even if you're in immigration proceedings, that does not stop you from being able to get your green card through special immigrant juvenile status. So what would happen in that scenario would be that if the I-360 is approved with immigration, USCIS, your lawyer will file a motion to terminate the immigration proceedings and request that the I-485, that the case be terminated so that the I-485 can be filed in immigration court, with USCIS. Now, if the judge approves, then the case is kicked back to USCIS and the I-485 process takes place there. If the judge doesn't approve of that, then the I-485 hearing will take place before the judge. So as you can tell, special immigrant juvenile status is very it's a bit complex in the sense that there are just so many stages, right? And it requires a knowledge of the law. So it's something that you want an attorney to do for you. Now, what I'm going to say is, if you have a child who's under the age of 18 or 21, consult a lawyer to see if your child qualifies, right? And if you're a young person and you don't have anybody, you can do that on your own. You want to make sure that you don't lose this opportunity to get a green card, because it's so painful to talk to a young person who could have gotten a green card through special immigrant juvenile status, but is now barred by their age, right? And the thing about young people, you come if you're in this country without a status, it's so difficult for them. It's difficult for them to get to school because they don't qualify for loans. Difficult for them to get jobs. It's just such a hardship for a young person to face, to be in a country where there really is no way for them to get their status, get their papers, come out of the shadows. So if you know somebody who may qualify for special immigrant juvenile status, this is a great video to share with them, okay? Because I really want to make sure it is my passion and it is my mission to help young people get green cards so that they can enjoy the vibrant life that they could here in the United States. So I don't see any questions, and so I'm going to sign off because I actually have something at 2:30. But after, I just needed to say this to somebody who may need to hear this, because it's really hurtful to see young people that I could have helped, or many other lawyers could have helped, and now it's too late. So it doesn't even matter if you already have a case in asylum court, or you have asylum hearings or asylum petition. You can file more than 2 petitions. So think about it. If you qualify for special immigrant juvenile status, or you think you may, by virtue of the fact that you're under the age of 18 or under the age of 21, consult with a lawyer, okay? We're here to assist you. Again, if you need to talk to us, my number is 973-993-1900. Have a great weekend, everyone. Take care.